Hello, thank you for joining us today. I'm Katie Cook with ISAC, and I'm here with Christy Harshbarger, General Counsel for ISAC, and our presenter, Mike Bennett, Assistant Iowa Attorney General. Mike will be speaking on the topic of autonomy of a county officer and separation between boards. Christy and Mike will be taking some questions at the end of the presentation, but please feel free to submit your questions or comments at any time. I will now hand it over to Mike to begin his presentation. Thank you.
Good afternoon. I am Mike Bennett with the Attorney General's office. I'm going to talk to you about county independent boards this afternoon. I've been with the Attorney General's office for a little over 14 years now. I work for the division of the office that does training and provides legal support to the county attorneys throughout the state. So I specialize there in criminal matters and also there's the county attorney's civil duties. So I frequently field calls from your county attorneys and assist them in helping to represent on the civil end and then help them with their criminal prosecutions as well. So I guess just a disclaimer before we start here. We're going to be talking about independent boards today. As the county attorney is your statutory counsel under Iowa law, if you have questions, I'd be happy to ask, but I ask that they not be specific facts or issues that are before your county right now. That advice needs to be provided by your county attorney, and I can't really give a good answer anyway without having all the facts. So, but I'd be happy to answer questions of a more general nature today. So let's get started here. I wanted to do a little bit of an overview of county government structure. I'm sure a lot of you will be familiar with this from your experience, but let's start off with the idea of home rule powers. Really, since the early 80s, we've been operating at the county and the city sooner than that under home rule powers. Prior to that, counties were under Dillon's rule, which basically said that unless the legislature specifically granted a power to the city or the county, they weren't able to exercise those powers. Now we're kind of on the flip side of that after the home rule amendments and the passage of Chapter 331 in the early 80s. Now counties, when they're dealing with things that fall into local affairs and the basic police powers, the health, safety, and welfare of their citizens, have the ability to act in those areas unless the legislature has indicated that it's an area that they are reserving for their own powers, or unless it's inconsistent with those powers. So there are a few areas that you don't have an ability to act in. First is the taxing authority all has to come from the state. So every tax that you pass at the local level has to have a statute that supports it in the first place. You cannot lower state standards below what they are set by statute. You can set higher standards generally if it's within your police power areas, unless there's a provision in the code that says you can't, or it would, or in situations where it's clear that the legislature has sort of encompassed that area totally. If there is a conflict with the city and its ordinances, their home rule powers are going to prevail over the counties within their city limits. And everything must be consistent with state law. It can't create an inconsistency that frustrates the state law provisions. A couple new ones that we had in the last few years. You can't regulate the sale and marketing of consumer goods. I think this was somewhat in response to the fireworks issue, but it also encompassed some places in other parts of the country that have done plastic bag ordinances at the city or county level and fountain drink size ordinances. But that would be, it would be broader to hit other things as well. And this year they just added this one, and I'm not really, haven't heard the backstory on it, but you can't have any condition of financing or transferring title to real property under a city ordinance. It sounds to me like that probably, arguably, is not something that would have been permitted under the general home rule powers anyway as a police power, but they did add that specific issue, so there must have been something out there where someone was trying to do something like that. So the legislature still has retained the ability, when they want to come into an area and say, we're going to legislate in this area, and cities and counties cannot. So that power still exists under the the home rule powers, but until they do so, in the areas that you're able to regulate in, you're pretty free to try new things. Okay, Iowa Code 331-301 is the statute that actually puts the home rule constitutional powers into place, and it vests the home rule powers of the county in the Board of Supervisors. And so generally the home rule powers are presumed to belong to the supervisors. Another provision elsewhere in the code has assigned those powers to one of the other offices or commissions or boards in the either appointed or elected officers that are created by statute. So the Board of Supervisors have everything that isn't specifically granted to one of the actors at the county level. And that's sort of the operative language here is this, except as otherwise provided by law. So that's what provides the shift to another entity within the county if that power has been delegated to someone else. Okay, so because of the fact that not all of the powers landed in the lap of the Board of Supervisors, there are different islands or different areas in which the power the counties possess are divided between different offices and different boards and agencies. And so there's a separation of these powers where people have ability to act in their own areas, and the other parts of the county government are kept from operating in those areas. If you think about that, that's not really that unique. It's probably true of practically every level of government that we have. At the state level, we have the legislative branch, the courts, and the executive branch, and then we have all of these agencies within the executive that have little pieces of the state sovereignty. We have, the Civil Rights Commission. We have the Utilities Board. We have all of these entities that exercise some of the authority that the state possesses and has powers in those areas. So this isn't really that unusual. There really aren't many. I was trying to think of an entity that isn't a level of government that doesn't have that kind of division. The only one I could come up with almost has unified powers are the township trustees, because there's a very few things that are assigned to them, and they really have a clerk and 3 trustees, and that's it. So there aren't any departments or anything to route other powers to. But everybody else is operating under this idea of various statutory and some others that are created actually by the entities having some of the powers that are granted to counties. So in general, the split here is the Board of Supervisors have the power over passing county legislation, passing resolutions, ordinances, and motions. They have the power to fix a tax if it's allowed under the state code. They can't create new taxes that aren't already provided for in the code, but they are able to determine what those taxes will be. They do the appropriations to the other parts of the county. They're the ones who decide what everyone's budgets are going to be for the most part. And really anything that's not assigned to anybody else. They have those home rule powers that haven't been specifically assigned to another county officer. We have the elected county officers. So this would be the sheriff, the treasurer, the recorder, the county attorney, the sheriff. Am I missing someone? The auditor. So all of those, if you go to the code, you can find a chapter or more than one chapter that will contain the duties and the powers that the legislature has given to each one of those officers. So the idea here is for those areas in which the legislature has granted these other elected officers specific duties and powers under the code, they don't answer to the Board of Supervisors or to any of the other officers at the county level, but they answer directly to the electorate that selects those folks every 4 years. We have statutory unelected officers. So we have an assessor that is appointed by, actually by what's called the Conference Board, which is a group of 3 different entities: the County Board of Supervisors, the mayors of the city and the county, and members of the Board of Directors from all the school districts. And they kind of vote in separate blocks to decide who the assessor is going to be, and they set the budget for that office. We have the county engineer, who's hired by the Board of Supervisors. We have some other offices, such as the weed commissioner and others. Mostly they're appointed by the board. And then we have county boards and commissions. Now these statutory boards have their duties and their powers actually defined by code. So they actually, these officers and elected or unelected statutory officers have powers that are also peeled off the home rule powers that were granted to counties. And so in the areas where they are granted those powers, they have sort of the last say in those, in making those decisions. And finally, we have county-created officers or agencies. And these are, they derive their power from the Board of Supervisors. The board is able to create offices, agencies, et cetera, that they can delegate some of their powers to as well. You know, the county, for instance, you may have an office that does your information services, your IT services. The board is, if you have an office like that in the county, that emanates from probably the board's power to provide equipment and sort of the physical plant needed to actually run your offices, the equipment and stuff. So again, we've got these 4 different sort of buckets we can put the various entities in, and there's sort of an intent, I think, especially the ones created by statute, to recognize that the powers at the county level, like they are in most, at all other levels of government, are going to be separated between various officers and commissions. So what's the purpose of having these boards and commissions rather than just having the Board of Supervisors try to regulate or handle all of these things on their own? Well, I think there are some pretty good positive benefits of having these, for the most part, at the county level. At almost always at the county level, these are private citizens that are not paid and are doing very helpful work for their communities. First of all, it broadens the input that goes into the decision. You may bring people into these decisions that maybe wouldn't be reflected otherwise within the government structure. You get participation and of these people into these decisions, and so they, it gives a way to give more credibility to these, and also to make sure that you're serving the needs of the community as actually exists out there in the public. You oftentimes can bring expertise or new perspectives into the process through these citizen board and commission members. Expertise, for instance, the health board requires that there be a physician as one member. Now, the health board makes a lot of decisions and provides a lot of services that are fairly technical in nature. They provide direct health services, vaccinations. They're involved in sanitation, private sewer and water delivery systems. A lot of regulation that has activities that involve items of expertise. And so having a physician on the commission can assist in making sure that they're filling the needs of the health needs of the county better. The Veterans Commission, all the members of that commission must be veterans. And there's a preference under that particular statute to have, if possible, selecting veterans from different conflict eras on that board or on that commission. Very clearly in that situation, we have people who have experienced the same kinds of challenges that the people that are being served by that commission have experienced. And having that experience behind them is of great benefit in understanding what the needs of those people are and to be sensitive and responsive to those needs. Boards will also give people maybe who don't even have expertise at the front end, but certainly after working in the area for a ways gives people a good chance to develop expertise in the various areas covered by those boards and commissions. That gives you people in the community that understand what's happening. They can go out to others and explain what your county is trying to achieve. And they can, because they're focused on one thing, they can develop expertise that if that particular activity was done by another part of the county, maybe the board of supervisors itself, they just wouldn't have the ability to spend enough time to get that expertise. They sometimes can help to focus issues a lot better. The zoning commission is an example of that. If you have zoning in your county, you're required to have a commission, and your initial zoning ordinance is passed after the zoning commission has done some studies, created a model or a proposed comprehensive plan, and it sets out what the long-term goals and expectations are for how development is going to go in the county. The zoning commission also generally drafts a draft of the zoning ordinances or recommends what those regulations are. That's a very large task, and having the ability to have a commission, ultimately all those things are recommendations that go to the board of supervisors that actually make the decisions, but having people spend a lot of time with those issues and try to sort of winnow them down and get something workable, it really helps to focus the issues and helps the board be able to act on that really big task of trying to figure out how the county might want to look 20, 30 years down the line. Managing workload, obviously, there's a lot of input that needs to go into decisions when you have these boards or commissions that splits up those decisions into workable working groups that can manage it better than trying to do that all by one board or one group of people. And it saves resources. I mean, we have a lot of people spending a lot of valuable time working on these issues. If you were paying staff members to do that, it probably would be a significant cost to the county. So there are great benefits to having these operating within your county. So what we see in the structure of county government is that it is by design, it has islands of power where people are given different duties and different goals and are supposed to be operating separately in some regards so that the areas that are assigned to them get the attention they deserve. This is a quote that you see in a lot of cases where there are disputes. It's cited, this citation comes up in a lot of cases where we have disputes between different parts of the county as to you know, whose job is it to make certain decisions with boards and commissions. So with few expectations, however, our statutes establish autonomous county offices, each under an elected head. And that would also apply to boards or commissions that are appointed. This particular case involved a dispute in Lee County where the Board of Supervisors had set minimum qualification for standards for the deputy clerk of court. At that time, the clerk of court office was actually a county department, and the clerk of the district court had the power to appoint deputy clerks. This case established that in making appointments, the board had the ability to approve a clerk, but couldn't set minimum qualifications. I think that would be the case under the current law too for the other deputies within the various county elected officers. So one of the issues that arises frequently in the local government area is the question of holding multiple offices, where we have people forming the same or functions in different parts of the county government at the same time. So we talked about the islands of power before and how there's a recognition that some of these things need to have their own powers and be sort of separated. One of the risks that we have when people start serving in multiple roles is those separate islands of power where each one of these things is deserving of its own attention. Sometimes those get a little bit clumped together, and you don't have maybe the separate attention that they might get if there were not as many crossover members. So there are some statutory limits, and Section 39.11 of the Iowa Code provides a couple of pretty straightforward rules on holding more than one office at the same time. Statewide elected officers can't hold any other elected officer. So anyone who's a statewide elected officer, like the Attorney General, the state treasurer, the governor, all those people can only hold one elected office at a time. Other elected officers at below the state level can't hold multiple elected offices at the same level of government, and that's the operative language used in the code. It's not 100% clear what that means just by its plain language. We have an AG's opinion issued in 1993 that says same level doesn't mean all local offices are clumped into one group. It means you can only have one elected office at each political subdivision level. So that would be the school is one level, the county is a level, cities are one level, township is one level, and you can sort of, there's quite other ones that they're out there as well, but that's the limitation there. The other main thing that kind of limits having more than one office at the same time is a common law doctrine that has been in our law really since before statehood, called the doctrine of incompatible offices. So the first thing to know about this is it only applies to offices. It does not apply to people who are merely employees of a government agency. So we're talking about people who are actually officers of various entities and whether or not they can hold those two offices at the same time. So offices are usually something that's created by legislative authorities, so they're either created by the legislature or by powers that are granted to another government agency or a level of government by the legislative authority. An office will have delegated at least some little piece of whatever that government entity's sovereign power is. It doesn't have to be a broad one, but it has to be the ability to make a decision to wield the power of that entity, one bundle out of the bundle of sticks, or one stick out of the bundle of sticks of their power has to be granted to that office. It has to have duties that are defined, and that's usually at the local level would be defined by either a resolution or an ordinance. And they have to wield that power, that duty to make a decision without any superior power that can make a different decision. So it's got to be an officer has to be the final decision maker on something. And finally, it has to be permanent. It has to have some permanency. It's got to be something that doesn't. It's not like an ad hoc position that can be, that's temporary or anything like that. So if you have all those attributes, you have an office. So the question now, after we know that somebody is serving in two offices, is are they incompatible? And generally, the questions here is the office, is one office subordinate to the other? In other words, does it in some way does the office, one of the office that's being held, have the ability to supervise or overlook the duties of the other office? If that's the case, it's a problem, because if that's true, we want two different people to have it. You don't want somebody supervising themselves. Are they inherently inconsistent or repugnant? In other words, and it's funny because repugnant means, if you look up the definition, it means inconsistent. So really that means, is it inherently inconsistent or inconsistent? But so basically the question is are the duties such that if somebody's doing both of them, they're creating inconsistencies or the potential for inconsistencies? Is it improper for somebody to serve in both and do really the bottom question is, can somebody sit in both of those offices and be serving those to the fullest extent and championing whatever duties that those two offices have if one person is doing both of them at the same time? An example of this is city mayors and county board supervisors. So a city mayor, we talked earlier about the conference board. That's the group that selects the assessor and decides what their budget's going to, the assessor's office, what their budget's going to be for a year. City mayors, every mayor in a county is going to be on one voting block and will be statutorily will be a member of the conference board. likewise, at the county, all the county board of supervisors are going to be another voting block. So if somebody is a city mayor and a county board of supervisor, they would have a vote on both of those voting blocks. And there's 3 voting blocks. So if you can get 2 of those voting blocks to agree on something, they can decide how much the assessor is going to make, or they can decide what the budget for the assessor's office is going to be. So we have an opinion that looked at that and said, no, those are incompatible offices. There's enough of a clash between the duties of those that it would not be proper to have the same independence that each one of those voting blocks was intended to have by the statute. So,
and Mike, we had a question come in about could someone be a county elected official and serve on a local school board? Would that be the same analysis as the mayor and the board of supervisor?
it is, again, it's on the local school board. I think, if I recall correctly, the conference board selects someone.
One person.
Right. I believe it is not all members, and so there might be an opening for that. If a person would like that question looked at, we might be able to. I can't render an opinion if we haven't done one before, but that might be very well one that we've done in the past. So,
okay.
So let me just write that down.
Sure.
And maybe if the person wants to leave their.
Yeah, we've got their name, so we can track down their contact info
Okay.
for you.
So we're talking school board and what?
No, it just says county elected officials. I don't know exactly what position.
So it would be important for that person to let us know which one, because it would be highly dependent on which. Okay. Very good. All right. So a second issue that is separate, and let me just go back. Let me go back to the incompatibility. Incompatibility does not care who is in the position. It just asks what the two. In other words, it's not going to look at the individual who's holding the office. It's not going to ask anything individual about them. All we're doing is comparing duties and powers between those positions to decide if there's an incompatibility. So which particular person holds those isn't important in that analysis. Conflict of interest, on the other hand, is specific to the person holding or acting in different manners in different parts of its government or different governments. So it asks if that person's personal obligations, allegiances to either another public office they hold, their non-governmental activities like their employment, the relationships they have, their spouse. It asks if all of those things in the background that make us us mean that in a particular decision that is official, you're going to be able to make an unbiased decision. So generally, these conflicts of interest tend to clump around personal interests that people have, their profession or their employment, financial are often important, are likely sources where people might have an issue deciding or acting on a particular action that's before the board or commission that they're on. So it applies to individual actions. It's not structural. Conflict of interest does not keep someone from serving in a particular position itself. It just keeps you from acting in a matter where you have a conflict of interest. Now, there may be situations where you have so many conflicts of interest that you would have to abstain from so many actions that it would not make sense for you to be involved in that particular government position. And that's just although it's not a legal basis for keeping somebody off, it's one of those things that people should reflect on and decide, am I really the right person to do this job for the public? If I have so many conflicts of interest, I'm not going to be able to be effective in a lot of important areas. So occasionally that happens, but for the most part, these things come up. They do come up frequently, but they don't prevent somebody from being effective in the areas where they don't have a conflict. Okay, we have a special provision under Chapter 331-216 that applies only to county supervisors. And I'm not aware of any other similar provision elsewhere in the code for any other level of government. This provides that unless provided by statute, a supervisor can serve on an appointed board, commission, or committee of the state, political subdivision, or nonprofit agency receiving county funds. So what this does essentially is relieves a county supervisor from the bar that would often come into place for incompatibility for serving on some of these other entities. It does not relieve if they have a conflict of interest in making a particular decision. So the fact that you can serve on a board that may raise some conflicts of interest does not relieve you of the duty to get yourself out of those decisions where you still have a conflict of interest. This one comes, the question comes up frequently, the second one here. Can a board supervisor who's also a Conservation Commission member vote on a budget for the commission? I don't think we have a formal opinion on that, although I think there's been, oftentimes the advice has been given that that's probably a vote that someone should abstain from. You think about the way that this, this shows you how the different perspectives and the different duties of the positions may cause some friction between one person making this particular decision. The Board of Supervisor sitting on at the budget their job is to try to figure out how to allocate resources between all of these needs that the county has, and they're all important. But ultimately, you've got to allocate those resources in some way. So your duty is to a broader area of interest than the Conservation Commission. Now, the Conservation Commission, as a member there, it's your duty to try to provide the best recreation and other services for people's leisure and for enjoyment of the natural resources of the county and preserve those things. So you might find yourself in a situation where those two tugs are tugging a different way, and it may be one of those votes that would be proper for a person to not engage in, since they really owe a duty to both of those entities that is somewhat different. So generally, if you find that you have a conflict of interest, I shouldn't say generally. The rule is once you identify a conflict of interest, you're supposed to refrain from taking any action on that, any official action on that area or that item. So you should refrain from both the discussion and the vote. So it's not enough to, if you have a conflict, you shouldn't be steering the decision with your input and then just refrain from voting, because you've already affected the decision or potentially by engaging in the discussion. So that is really required to get out as soon as you spot that there's a conflict. And I should say, I didn't have this in the slide, but the importance of that is if there is a conflict on an action, then if it's attacked in the future, if that vote is important enough that somebody wants to challenge it, if they can show that the conflict existed, it puts the action into question as to whether it's legal or not. Particularly if your vote was necessary to get passage. Some might argue that the fact that if you were in the discussion, you influenced the decision might be a basis for making an argument that the decision is invalid as well. So it's very firm that if your vote was decisive and it was conflicted, then that is potentially a void action. 28E agencies. If a county, I'm sure most of your counties are involved in 28E agencies. This is the chapter of the code that allows various public entities and even some private entities along with public entities to do things cooperatively in an agency, create an agency to do things that you have the power to do on your own, but would work out so much better if you had other people assisting with you. Probably the one that always comes to mind to me are the solid waste authorities. Running a dump, I guess that's not the right term anymore these days, but running a solid waste disposal facility is a very expensive, huge undertaking. It makes a lot of sense to regionalize that and have a lot of different entities able to fund the long-term costs and responsibilities of that. When you're sitting on, and as a part of almost every one of these 28Es, there's going to be representation from each member agency on that board of directors. And our office has looked at that question and said, well, can you serve on both of those? Isn't that a conflict? And the answer that we came to is no. The whole idea of that cooperative effort is to have every one of those agencies' interests looked out as they do this cooperative effort. So having sort of representing your county's interest on that board is part and parcel of what the 28E probably, most likely in most circumstances, that's the reason why there's membership by the various entities that form that. So that is not a conflict. The mere fact that you're also an officer on this in the county, so that's sort of the status there. It's a little bit different than other agencies, which aren't, where you have separate entities within the county itself.
Mike, we have another conflict question kind of along those lines. Trying to decide where the loyalty should lie. So if a supervisor is on a board or a commission and a decision needs to be made that's in the interest of that board or commission, but maybe not in the best interest of the county, where is the loyalty supposed to lie for that person?
I think that's probably one of the situations where you need to bow out of the decision. And that's sort of the classic problem with conflict of interest. And that's something that you should think carefully as you enter these other boards or commissions, especially if you are a county that has a 3-person board. Because if you have to abstain from a vote and there's not consensus on the other 2 votes, you may have a decision that's not able to be made. So I think people need to really carefully think about the potential risks of appointing onto some of these boards or commissions where there's oftentimes issues before the board of supervisors on, and decide whether just because the power exists, it sometimes might not be in the best interest of the county to have people necessarily serving in those dual roles.
Then someone else just asked for you to repeat on whether the supervisor is also on the Conservation Commission to participate in the vote on the conservation budget.
I don't know if we have a definitive answer on it. I know that I would be worried. I know that I would be concerned with that. It does call for, especially if and every budget situation is tight, right? That's just the way it is. I think it always leaves the potential out there for someone to question. But we don't have any. I mean, we don't have a definitive ruling on that. We've never had a court case on that to that effect. So I know we haven't done a formal opinion on that issue.
Thank you.
Let's talk a little bit about removal of county board members or commissioners. We have a statute, 331-321 sub 3, within the county home rule area. This provides the default process for removing appointed county commissioners or board members. This same section provides for appointments as well, so it talks about that issue. And here there's under this process, if there's a removal, the board issues a written order of removal. It has to give reasons for the removal. We just had a case come out last week, literally, and I don't think there's been much case law in this prior to this, but the Court of Appeals issued a case that we'll be talking a little bit about later as well, that indicated that the reasons for the removal in that case was lack of communication with the board on matters in the commission. So they said basically the court there found that they didn't have to be really detailed, that they could be somewhat vague, but sort of convey what the general issues are between the board and the removed member. They're filed with the auditor, who mails it certified to the person. The person then can request a public hearing before the board. There's time frames that are referenced in there. But essentially what this does is it allows somebody to ask for a hearing before the board on their removal. Now, this is familiar to people who do public employment law. What we're talking about here is what's known as a name clearing hearing. If you take an action like this that could possibly affect that person's reputation in the future, their ability to be employed, etc., there is a body of case law in federal employment law that says that you have a duty to give somebody a chance to have a hearing where they can explain their side so they can potentially clear any cloud that's over them from that action. So that's what this is an opportunity for that person to do so. It doesn't mean that you have to change your course on it. Obviously, you could change course after that person presents their information. But it gives them a chance to get, since you've done an official action to remove them, it gives them a chance to explain why they think that's either not fair or that the removal wasn't proper. And here's a site to that case. You go to the Iowa Court of Appeals website. It's on their recent, and click their recent decisions tab. You can find this Helmick versus Louisa County Board of Supervisors. That was a health board, member of the health board. Actually, members of the health board were removed under that section. So that particular section applies generally where a board or commission at the county level does not have any other specific provision as to what the standard is for removal. We do have some other boards that do have specific stated standards. For instance, the Civil Service Commission, when you look at their statute, says that the appointing authority, which in this case the appointing authority for civil service is the county attorney gets to pick one member and the board gets to pick two. If they are for incompetence, dereliction of duty, malfeasance in office, or other good cause. Those are some pretty serious levels of either misconduct or just failure to meet the basics in serving in that area. So if you remove somebody, you're going to have to put on some pretty good evidence as to why that's proper. Board of Adjustment is for cause, so that means it can't just be because you disagree with them. It has to be something that rises to the level more of misconduct or malfeasance. On written charges at a public hearing. So again, that idea of they would have a chance to have a hearing on that issue. One thing that you notice, both the Civil Service Commission and the Board of Adjustment are entities that are exercising something that looks kind of like this kind of thing that a court does in the area they operate in. Civil Service Commission reviews discipline of deputies in the sheriff's office and determine whether or not discipline was proper in that situation. So it looks a lot like a court hearing. Board of Adjustment grants variances and exceptions from the zoning statutes, and those things are also kind of similar to what a court action is. You're deciding particular outcomes for individuals based on their particular state of their property. I think maybe if you look at the code, you see that there's sort of there's a undercurrent here where if somebody's doing something that looks like a court-related action, it's harder to remove those. You're going to need more basis to remove those people other than you just don't agree with them. Because I think the code is trying to build into those entities, those boards or commissions, some independence so that they can't be swayed or threatened for removal if they don't agree with, if the appointing authority doesn't agree with the action they're going to take. So again, these quasi-judicial duties seem to have agencies that have a significant amount of duties in those oftentimes will have these higher standards for removal. So let's just get onto that issue a little bit too, the difference between quasi-legislative and quasi-judicial boards or commissions. So quasi-legislative quasi just means basically somewhat like, not exactly the same thing, but kind of like those things that are like legislatures, bodies that are like legislatures. Generally, they're making broad policies and rulemaking, things that affect broad groups of people or everybody even in a community. Here you're weighing interests of the community that are broad. What's best for our community as a whole, or big groups within the community. We're not really determining individual rights at this point. It's not aimed at any particular person. Things like setting zoning standards for a whole area, or when the conservation board decides what closing hours are. Those apply to everyone who uses the park. It's not really picking on anyone in particular. Those things are quasi-legislative. The flip side of this are quasi-judicial actions by boards or commissions. This is where you're applying a standard that exists to particular facts or circumstances, and you, based on whatever this law, this legal standard out there, you're determining a person's individual rights or a small group of people's individual rights. So this is a decision that's likely to have a significant impact on one person or maybe a small group of people. It looks a lot like a court hearing. And because that, it has a process that's like a court hearing. It needs to be a public hearing. Most of the stuff, well, actually really everything we do should be a public hearing if it's a quorum or greater, right? It often will have readily identifiable people who are either opposed or for whatever the action is. It tends to have winners and losers based on the decision. It's localized, and again, the decision will affect a group small group of people much more acutely than the general public. We talked about the Board of Adjustment before. Whether you grant a variance or not, it sort of fits the categories very well. If you think about that, if my neighbor wants to build a garage, but he wants to build it beyond the setback limit that's in the zoning code, you know, definitely he or she has an interest in building their garage where they want to. I have an interest in not having a garage that's 2 inches from my, you know, my garage or my backyard. So there's definitely a winner or a loser in that decision, and that would be a quasi-judicial action. Why does it matter? We have case law that has been developing over the last couple decades that say that when you're doing a quasi-judicial role, when one of your commissions or board is in a quasi-judicial role, making decisions that impact on individuals under those standards we talked about, that there is a due process right that requires that the decision makers be impartial, that the decision is based on the information received at the hearing, and that there is an avoidance of ex parte or outside of the hearing contact. So when you have people sitting on these boards, these that have quasi-judicial roles, or if you're sitting on one of these, you need to be aware of these restrictions, and you need to discuss in the committee or the board or commission how you are going to avoid getting information from parties or from other interested people in the community regarding this particular decision before you have the hearing or even during the hearing. The information needs to be coming in through the hearing process itself, just like you'd expect in a trial, right? You wouldn't expect people to talk to the jurors when they're in recess and try to convince them to convict somebody of a crime. Or if you had a civil suit before a court, you wouldn't want you know, people talking to the judge and trying to sway them one way or the other outside of the court proceeding. There's a potential for voiding any action taken if this isn't respected. We have some zoning cases where that has been found. So maybe an area to do some training on your boards or commissions where they're sitting in this kind of decision-making mode. And I would say most of a good portion of the boards or commissions we have at the county level have at least some aspect of their duties that would fall into this quasi-judicial role. Quasi-legislative role is different. That's much more like so if it's like the court acting in the first one, this is like the legislature. And we all know that you can call up your legislature and legislator and give them advice as to what you would like to see them do. In fact, that's sort of the expectation. We want them to get a lot of input from people that are affected by the decision. So there's no limitation when you're trying to pass a new ordinance or something like that of broad nature. So that's encouraged and is positive in it. It doesn't require the board members to be neutral either. They can come to a legislative role with already an idea on what they want to do. In fact, probably most of the time that's how they get generated as an issue before the board, right? Somebody decides this might be a good idea for us. So there's nothing wrong with that. Always remember the gender balance. This was a hot issue a few years ago when they applied it to the counties directly. I haven't heard much in this area since then, but just be advised that there is a requirement on every board or commission at the county level, as well as at the state level, that you have balanced numbers of members in the gender area. If it's an even number, it should be equal. If it's an odd number on your board, then being off by one person is the best you can do, right? So that's fine. There is an excuse for imbalance if there is a good faith effort to try to fill the position, and after 3 months you aren't able to do so. I think at points we've seen that good faith effort not being maybe as good a faith as effort as it should be, so that you really need to go out and shake the bushes and see if you can find somebody to serve. I know from talking to people throughout the state that we are seeing in a lot of communities a difficult time filling the roles of commissions and boards. So I know it's definitely a big challenge, but it still is required, and it improves the output of the board to have people with different viewpoints and backgrounds on there. Okay, how are we doing on time?
We're right at 2, but you can feel free to finish if you'd like.
So we've got a few questions too.
Okay.
I don't know which you'd rather handle.
Well, actually, all of this last section is some examples of boards and commissions, and I sort of chose ones that we tend to get more questions about because. So maybe let's do a real quick on this. We talked a little bit about the conservation board. You know, they have custody of the parks. Some of the things that sort of come up is first of all, if they get gifts for conservation from people, if they donate property or monies, then those are retained in the conservation board. They are able to generate user fees, which is kind of unusual for, I guess not that unusual, but there are oftentimes significant amounts of money being collected through parking, camping fees, things of that nature, concessions that they might have in parks. They can create crimes that are simple misdemeanors that are their regulations in the park if they go through the proper process of getting those published and posted. And they actually have employees that are peace officers. Generally, the Conservation Board appoints its director, approves that salary, and then also the director can hire people and do their salaries. We've got an opinion that says that actually, though, the Conservation Board still has the ability to review the salaries and the hiring decisions made by the director. The areas where we see some friction sometimes, I think, are they have a non-reverting reserve fund that the Board of Supervisors can put money into a capital projects fund for the Conservation Board, and that does not revert at the end of the year. It's a way for them to build up cash over the years so that they can do some of the bigger capital projects they might want to do, acquire more land. The appropriation that they receive from the county annually and the money credited to the reserve has to be greater or equal to the revenue and gifts that they have received. So they have some protection in the budgeting process, and they have the power to expend without the Board of Supervisors. So their claims do not go, they go directly to the auditor to be paid on their demand. So I think that has also caused some friction in the past. So we get questions on that from time to time, since it's a little bit different than most other boards. Board health is a common one that we have questions on too. Again, we talked about how they have to have a doctor. They enforce the state health laws. They can pass local health regulations that, if approved by the Board of Supervisors, actually become simple misdemeanors. So they have some significant powers there that they share with the Board of Supervisors. I think the area that we see the most friction on this is the Board of Health determines the pay of their employees. They also are required to have something akin to the state merit system for their employees or the county civil service procedures. So if you're in a county where your employees are at will, these employees are under a little bit different regime. I think that causes some friction in counties as well at times. Not always, but those issues have raised problems in the past as well. As we know from this recent case, they can be removed under the notice of the reasons. They don't need. It doesn't need to be more than that. I don't think we need to cover. I think these other ones are not as important. Are there some questions we can?
Yeah, we've had a few come through. How does the Board of Supervisors participate with other elected officials in the appointments of deputies?
They don't. We have some opinions on this. The role, the decision to appoint, and we're talking the deputy county officers, not the deputy sheriffs. We're talking deputies within the other elected offices.
Yep.
The term deputy under law means somebody who acts in the direct, has all the same powers that the principal has. So the appointment of a deputy by an elected officer is in a sense giving somebody all the powers that that person has. And that is such a fundamental transfer of trust that decision is wholly the principal's decision. There is a provision where they approve it, but we have prior opinion law that says that the only time that should be with, actually we also have case law. I think it's Smith versus Des Moines County that says that absent some really, really, really good reason, that should be a matter of course. So if you're going to not approve such a appointment, there better be a really good objective reason other than I just would rather have someone else.
This one goes a little bit into opening open records, but do all boards and commissions that receive public funds need to follow open meetings, open records?
Yes. Every public body at the state or local level is bound by the open meetings public records statute.
And then let's see. We got the emergency management question that we were talking about before this, actually related to funding. Does the commission have the right to approve, the Emergency Management Commission have the right to approve the budget and decide which funding stream to use, and are the Board of Supervisors required to accept and fund those decisions to the fullest extent?
I have not looked at that issue for a while. I know that it's out there as a question. I know that we do not have a definitive formal opinion yet on that issue, or I don't know that one's been requested. So I don't think I could answer that. That's something that would require really careful analysis.
The Veterans Affairs Commission. If the commissioner is going to be removed, is there any special process to follow because they are a veteran?
Well, I guess the question is if they have any rights under the veteran's preference.
Right.
I've never looked at that question before when it's a non-employee.
Yeah.
It's an office rather than a non-employee.
We'll get back to you on that one. Whoever had that question, we've got who had that question, so we'll check into that one. Because I know there's a process to write if somebody's an employee, but I don't know if that would apply to a commissioner or not.
The case law on the case law on the preference says that for an employee, it only applies to. It does not apply to people who are have a confidential relationship with the appointee. But generally would be it wouldn't be like it wouldn't go to a deputy or somebody like that that acts in the appointer's shoes.
Okay. A gender balance question. Do you have to remove someone to make your board gender balance if replacement would achieve that balance? I'm assuming that means you don't have midterm as opposed to a term expiring.
I guess that begs the question. This thing has been in place for quite a few years. I don't know that you can argue at this point that the appointment that put somebody into imbalance probably was not lawful. You need to look at which board it is, but most of these boards, as we indicated before, are covered by that 331-321, which doesn't really require that the person be shown to have done anything wrong. It's just you have to explain what the reason for the removal is, or if it's in one of those entities, I don't think there's any question that you could do so because you're trying to do so to comply with the law. But that might be one thing to ask: is what appointment puts you out of balance,
right?
And whether that is a lawful appointment.
And then the last one I think we have is a Board of Health budget question that might have gotten addressed, maybe. Can the Board of Supervisors do line item cuts to a budget set by the Board of Health?
I don't know the answer on that. I know that has been looked at it for some other. I don't know if the line item issue has been, the question I think has come up after the budget is approved, can they move between lines? And I don't believe that was a Board of Health issue, that was another elected official, or maybe multiple elected officials, and that has been found to say yes, you can move money from one line to another after the appropriation was done. I don't know that we have any opinion on the prior issue as to how you come to the number.
Okay.
I guess the thing to say on that would be that probably, though, that whatever you appropriate to them, they probably will be able to move funds around to different lines.
I think Katie might be sending you one more question.
We do have a couple more, unless
we
you'd
want
like
to
to.
keep going. Let me scan through them. Okay, when a term expires for an appointed board member, the example was Conservation Board, can the Board of Supervisors simply appoint someone new for the term, or is there a process that they're not going to reappoint?
I'm not aware of anything in the code that requires someone to be reappointed. And so I think the appointment power with the term inherently has in it the decision, the power to decide whether to reappoint or not to reappoint.
The next one's one I think I've gotten before, and I don't know the answer, so I'll be interested too. The compensation board, the county compensation board, each elected official is able to appoint their own representative. So does gender balance apply to that board, and how does that work? I can say what I gave as the answer for it. I don't see any exception for the county compensation board from the gender balance statute.
Right. I don't know if we have an issue. I don't know if we've done something on that before. I know there has been. I know I've seen something on maybe another entity where there are multiple appointers who appoint that have indicated that they need to be gender balanced.
Yeah.
And that might affect who you can appoint, you know.
Yeah, that's a tough one, because I don't know how you coordinate that, so who gets to make their appointment first then, and who goes on down the line, and then maybe has to pick a choice based on gender, but there aren't any carve-outs in the law that I've seen.
It seems to be pretty all-encompassing.
Mm-hmm. So that's a tough one.
Get your appointment approved first.
Yeah, yep, sign up early. Is that it?
Yep, I think that's all we have for now.
All right, thank you very much for attending.
And this webinar will be recorded and posted to the ISAC website at the end of the day. Thank you.
You're welcome.